Planning to file for a divorce in Wisconsin, one wrong move before you file could cost you thousands in assets or crucial evidence for your case. Most people rush to file first and plan later. That's where they go wrong. My name is Jeff Hughes and I'm the CEO of Sterling Lawyers. We are the largest family law firm in Wisconsin, and we see hundreds of cases each month, and that gives our clients an unfair advantage. In this video, I'll guide you through the 7 critical steps to prepare you for your Wisconsin divorce. Everything from meeting the residency requirements to securing critical information. And by the end of this video, you'll have a clear roadmap for starting your divorce process on solid ground and avoid costly mistakes. Okay, first, before I get into the 7 critical steps, let me just encourage you to do everything possible to save your marriage before filing. I would love it if you stop this video, and if that were a chance that you could do something more, please, I encourage you to do that. So I'm assuming as I go forward here that unfortunately that's where you are at in your relationship and that it can't be salvaged. If that's the case, I applaud you for putting the effort in and trying everything possible. So now, if you are moving toward a divorce, let me share with you these 7 critical steps to put you in the right legal footing to where you need to be. Number 1, understand the residency requirements. So in Wisconsin, before a party can file for a divorce, they need to live in the state for 6 continuous months prior to filing. Now, residency starts from physical arrival, not just buying property in the state or making your driver's license say Wisconsin or changing that. That does not give you residency. It's physically living here that it's required. Now, if you file and you haven't lived there that long and the court finds out about it, they can kick out your divorce and dismiss it down the road. So it's real important that you have lived here for 6 months. Okay, that's the state. Let me shrink it down to the county that you're going to file in. You must live in that county that you file in for 30 days prior to filing. Also, if your spouse has lived there, you could file in the county where your spouse has lived for 30 days. So one of you needs to have lived in that county for 30 days prior to filing. Now, like everything in law, there are some very, very minor exceptions, such as military service. So if you feel like you've got something going on where you might have an exception to that, consult with an attorney about your specific case. But as a general rule, it's 6 months in Wisconsin, 30 days in the county of filing. Okay, number 2, understand and know what the grounds for a divorce are in Wisconsin. And frankly, it's very simple to explain, but can be sometimes hard and confusing when you're in the midst of a divorce action because it may not seem logical, okay? So Wisconsin follows a process called no fault divorce, which means you don't have to have a reason for asking the court to divorce you. In the old days, you would have to show something like abandonment or adultery or abuse of some sort. There were other factors too that went into that you would have to demonstrate and prove before the court could grant a divorce. That's gone away now, and it's no fault divorce. Now, I'm spending a little time on this because I want you to recognize how to use this information once the divorce is filed and as you get into it. I have so many clients that have come to me over the years, and they want to share the pain that they've gone through and the difficulty in the relationship and things that their spouse did that was so frankly wrong and hurtful and destructive to their marriage and to relationship. And to them, it logically seems so relevant. Like, why would a judge not want to understand this or not want to hear testimony or evidence around this particular thing? This adultery, for example, that my spouse has done. Well, those certainly matter to the relationship and they certainly have impacted the relationship. But from a legal standpoint, the judge cannot consider those things when granting the divorce. Now, there are some situations where those things may come into play as it affects the parenting of the other party, of that spouse. But that's a case-by-case analysis. And I want you to understand from a standpoint of as you allocate time and resources going through your case, don't put them into proving fault or arguing about fault, because for right or wrong, good or bad, the courts, the judges cannot consider that evidence for anything toward granting the divorce. Okay, step number 3, gather all important financial documents. Now, it's important to understand something here. Wisconsin is a community property state. Now, what this means is that's the starting point, meaning all property is considered jointly owned by both parties. That's the starting point that the judges begin from when it comes time to divide property and divide debt. And they do that from a standpoint in the law is that they are to do it equally, meaning both parties share in that. They each get half of that. That's the starting point. Now, judges don't absolutely have to stay there. They can deviate from that, but you need to understand that's the starting point. Now, there's only, I think, 9 states who do it this way. Other states have more of an equitable distribution, meaning the judges have more discretion to divide property unequally based on factors that are in those states' laws. In our state, it's a community property state. So I point that out because that, knowing that, impacts how property is divided in your case, and then it will impact how you go about gathering documents. So you need to gather all of your important financial documents. Those will look like this: your income records, your pay stubs, your tax returns from the past few years, your W-2 statements, your spouse's W-2 statements, if you can access those. Same thing for pay stubs. All 1099s, if you can access those. Okay, so gather all that information. You need to create the beginnings of a file that you will need to understand your financial situation and how to divide that as your case moves forward. Gather all of your asset information. Okay, that would look like bank statements, retirement account statements, property deed, vehicle titles, investment accounts, all those things. Now, if you can't necessarily, and I can understand the reasons why, if you can't necessarily get the originals, at least get copies of all of these things. Take the time to gather all of that so you have a really solid baseline to start from for all of your assets. Third, also, gather all the information related to your debt. That's credit card statements, loan documents, mortgage statements, everything related to your debt and your spouse's debt. Gather that. And again, if you can't get the originals, at least get copies of those things. So for your insurance policies, those typically are life insurance policies, but gather all of those, both your term life and your whole life policies. Get copies of those if you can't get the originals. Now, once you get all that stuff, secure it in a safe place. Sometimes that may mean it's someone else's house. It all depends on the dynamics in your relationship, but store those things in a safe and secure area. So why? Why is it so critical to gather this financial documentation? Well, let me tell you frankly, in some relationships, the dynamics are very high in trust and there's no bad stuff going on, but that doesn't unfortunately describe every couple. And people do odd things when they're under the stress of a divorce. And it's just helpful and best practice to have all of your financial documents gathered and organized and set aside so no one else can get to them, so they're stored in a safe place so you've got them as you move forward, because you're going to need them anyway. And having them before there's a chance for them to turn up missing or to be, somehow modified is what you need to do. Number 4, protect your digital information. So often, unfortunately, I've seen clients discover through their case that their spouse is reading their emails or somehow is accessing their private information, their communications with our office, for example. It's just wise to change all of those passwords, okay? All of them, change them all, put them to something unique. Everything should be different. Every password should be different. And it shouldn't be the same password for every one of those, okay? That's important. So change all of those passwords and protect your digital information. Again, I understand that this won't apply in every single marriage dynamic, but people do odd things again when they go through a divorce, and it's just best practices to follow through and do that. Number 5, create a projected budget for yourself. Now, the reason why this is a best practice to do this before filing is that so you have some awareness of what your needs are going to be in the future. And a lot of times this is just to have an emotional preparation for that time to come. A lot of clients come to see us and they don't have any budget whatsoever. They don't work off of a budget. They don't manage their life off of a budget. And so now they're going to be asked to do that by the court down the road, and they're going to be changing everything in their life. And they need to have some idea of what their financial needs are going to look like. And this is a lot about being emotionally prepared and level setting your expectations. That's why getting this done and having an idea on this prior to filing is so important, because it may impact your decision on filing. You may need to wait. You may need to delay things a little bit until you're more prepared from a financial standpoint to do that. So when putting this budget together, first start with all of your expenses, your hard expenses, those things that you have to pay no matter what every month. And then work toward your discretionary expenses, things that you could cut back on if you need to, things that you could do without. Put all of your expenses on one sheet of paper, on one projected budget. Now, a lot of times clients don't have real good visibility into what their income is going to look like in the future. Sometimes they're not even working when they file. And so they don't know if they're going to have a job. They don't know what child support may look like. They don't know what alimony or maintenance may look like. That sometimes is out of our line of sight. But for the most part, our expenses should be. So we should know what our minimum expense threshold should look like, what income we need to get to cover those expenses. So do the time, put in the time it takes to do this. It is so important for you to have an awareness of these things prior to filing. Okay, number 6, prepare your financial accounts. Now here's what I mean by that. And again, this is getting into some stickier areas, because I will point out again that not every relationship will this be necessary for. Some dynamics are high trust and the parties work and communicate very well, but so many clients come in to see us where that's simply not the case. And so sometimes, and what I often recommend, is that clients immediately set up separate accounts. Now, it's very important here that you do not hear me say, set up separate accounts and fund money over to those accounts in a secretive way. That will do nothing but destroy trust that does exist between you and your spouse, and it will destroy credibility with the court. But it is important for you to have those accounts. If you have joint accounts now, even within the same bank, you can set up separate accounts. Okay, so set those up, maybe put a little bit of money in theirs and have them ready to fund with marital assets if you need to down the road. And talk with your attorney about doing that before you do it, because it's so important that you have a way to protect yourself financially, but it's also important that you don't do something that's going to cast doubt on your credibility with the court. If the court believes that you're transferring assets and hiding assets and all that, that will not bode well for you and your credibility with the judge. And likewise, if there's no need to create acrimony within your relationship by moving funds, don't do it, but have an option for yourself to do that. Have those accounts already set up if you need to do that, because eventually you will. You will have to do that to have your own account. So setting up ahead of time is just a wise thing to do. Okay, number 7, and it is a big one, and it's one that you cannot overlook, and that is this. Know how the 3 big issues in divorce will impact your case. And I would recommend for you to know this and know it well and know it accurately for your county is go talk to a divorce attorney that focuses on family law, that focuses on divorce, who practices in your county. Talk with someone, pay the money to do a strategy session to understand how all of the divorce law in these 3 issues will impact you. Now, our firm does that. Many other firms and many other great attorneys also do that, okay? You don't have to hire them for a full-blown case, but you need to spend time in a strategy session becoming very aware of how these 3 issues will impact your case. Now, here's what those 3 issues are. Number 1, there is property and debt division. That will happen in every single case. There's property and there's debt, and that will be divided. You need to understand how the law impacts your case, because there are exceptions to everything's divided 50-50. Inherited assets and gifted assets, but you need to, there's ways you need to hold those assets for that to happen. There's also discretion on the judge's part to divide unequally based on factors in the interest of fairness. Okay, now that's squishy. It's a lot of times judge by judge and how they do it, but they do have discretion. You need to understand how your judges in your county will look at your case. Now that'll happen in every case. The second issue won't necessarily happen in every single case, and that's with children. Some couples don't have children, but for those who do have minor children, meaning children under the age of 18, there will be orders on the placement, meaning where those children live, and the custody decisions for those children. Custody decisions have to do with major decisions in that child's life. You need to have an understanding of how the law will impact that in your case for your child or for your children. And the third and final issue, these are the only three issues in a divorce, okay? The third and final issue has to deal with support. There's two types of support. There's child support. Again, if you don't have children, minor children, then that's not an issue in your case. But you may have an issue around alimony. Okay, now alimony is the same thing as spousal support. One spouse paying another spouse, both during a divorce and after a divorce. Now, I'm calling it alimony because that's what everyone knows it as, okay? But the legal word for it in Wisconsin is maintenance, okay? So that's the legal word. That's what the judge will call it as. That's what you'll look it up online and that's what you'll see, okay? But everyone knows it as alimony, so I call it that because that's what we can all relate to, all right? So it's important that you understand how your case will be interpreted under those three issues. They are property and debt division, number one, children issues, number two, and third are support issues, child support and spousal support, maintenance back and forth between the spouses. Okay, so that's a mouthful. It's a lot there. Those are the 7 critical steps that I believe parties need to do before filing for divorce in Wisconsin. So if that video was helpful to you, and if you're ready to take that first step, then watch this next video on the documents needed for divorce before you file. I'll show you exactly which papers are needed and how to secure them before it's too late. See you over there.